Understand your road to freedom. Every phase our lives are in commerce. You need your strawman to operate in commerce. Your strawman has a license to operate in commerce, i.e. driver's license, marriage license, handgun license, occupational license, building permits, etc. A license is good as long as you want it to be, by your permission. When there is a fine for misuse of your license, you need to learn how to then switch the strawman to the living soul with the right to life, liberty, property, and the pursuit of happiness. The strawman is a transmitting utility that allows you to operate in commerce with a license to conduct your commercial affairs. Anyone operating in commerce without a license is committing a commercial crime. You and I need to learn how to become the representative or agent for the strawman and conduct all of his/her commercial affairs without getting involved. All crimes are commercial and are then regulated by commercial courts. Commercial crimes are murder, stealing, dealing in illegal DMGS, prostitution, practicing law, or making a legal determination without the permission or consent by assent of any party to a contract. All commerce is ruled by contracts. All courts, tribunals, are ruled by contracts. Absent a contract, the court, tribunal, will proceed to write a contract under cause/case #_. Will the defendant rise? What is your name? This is the signature for the contract. How do you plead? This is the giving of subject matter jurisdiction and becomes part of the consideration for the contract. All the arguments are the offer for the contract and the judgment is the acceptance for the contract. The court takes a complaint, turns it into a charge against the strawman, tries him/her on the charge, and then a judgment is rendered, which is a civil action, a claim, and this must then be accepted by the living soul. You accept the judgment in two ways, by silence and signing the judgment, or by appealing it to a higher court, a third party, who will then agree with the judgment. Why would you argue law or codes, rules, regulations, procedure, statutes when the contract is the law in your case? The redemption process or acceptance for value can then authorize the payment of the judgment. The judgment should be signed by the court clerk, for they are the court. In most cases the judge will sign the judgment hoping that you will accept the contract by one of the above two ways, by silence, or signature or appeal to a third party. Another way is the rejection of contracts allowed under Truth in Lending, and when the contract is about mortgages it comes under Regulation Z and Truth in Lending. Always remember, everything is in commerce and is ruled by contracts. Codes, rules, regulations, procedure, statutes apply only to the corporation that they were written for. You do not argue codes, rules, regulations, statutes in commerce, you argue contracts. If there is no contract, there is no case. There is no contract with a policeman, government official, federal agent, or federal agency, even with a license. A government or corporation is a fiction and cannot sign a contract or enforce one unless you enter into their organization or corporation as an employee and argue their codes, rules, regulations, procedure, whereby they then use these to enforce a contract. Read the book 5 times and then write your questions down, then call Commerce/Contracts, that's all there is. Page 1 to 3. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _contributions, Manuals, Additional _collections. Language English. Item size 138.1 m. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Added date July 13, 2020, 23:01 and 35 seconds. Coverleaf 0. Identifier: The Redemption Manual. Identifier ARC/13960/T0KT5N815. OCR ABBY Fine Reader 11.0, Extended OCR. PPI 300. Scanner Internet Archive HTML5 Uploader 1.6.4. Comment. Reviews. There are no reviews yet. Be the first one to write a review. The Redemption Manual. Book Reader Item Preview. Understanding Contracts/Corporations. My new motto is just say, no more. Catch the double meaning. It's time to understand what is really going on, open our eyes and take back our country. The best way to do this is to hit them where it hurts. Their financial statements. What is the most effective way to make others change? Change your behavior toward them. If you want a child to stop being mean, you simply tell that child that until he plays nicely, you won't play with him anymore. If that child needs you, he will quickly change his ways. So, we tell the police departments, county sheriff offices, states, and the feds that they aren't playing by the rules of full disclosure and tell them we won't play with them anymore. Now, when they change toward us, we still won't play with them because they are not cute, little children. They are giant corporations that have nothing to do with lawful government. Read that again, they are giant corporations that have nothing to do with lawful government. And that is the point. America hasn't been a sovereign nation with lawful government in more than a century. Some even argue that there never have been lawful governments as every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Cruden v. Neal, 2 NC 338, 1796, 2 SE 70. And the key phrase there is without his consent. You must voluntarily give your consent to enter into contracts with these corporations. Remember what Nietzsche wrote, everything the state says is a lie. The state declares they are a state and this is true, but what is a state? The state of Texas is a subcorporation of the United States which is a corporation operating in commerce for a profit. Now some may ask, what's the difference if they operate as a corporation? Well, if they operated as a not-for-profit corporation and the stockholders were we the people, then that might be okay. But the fact is that every municipality, school district, public works, state, federal agency, and the United States operate in commerce for a profit and you and I are not the stockholders. These corporations are privately held companies. Think about that for a minute. The entity we call government is actually a corporation that is not owned by the American people. Who makes the corporations responsible to the people? Do they watch themselves and never harm anyone? No, we have to go sue XYZ company because they knew their tires were causing hundreds of deaths, but XYZ company didn't want to take responsibility because the bottom line was more important to them than human life. Once the system went into corporate status, it ceased to be government. Before becoming a corporation, no one ever had to register to vote. Now they say that everyone must be registered. This is not true. Try it sometime. Go down to vote in a local election in which you are an inhabitant of that area, but are not registered to vote. Tell them that it is your right to vote and that you don't have to be registered. Most likely you will be allowed to vote, but they won't be very fond of you. You may be asking, doesn't registered simply mean, signed up? Not quite. When you register yourself, you record formally and exactly, in a list or the like. Sounds innocent enough. Now, whom do you register with? The registrar. A registrar is an officer who has the custody and charge of keeping of a registry or register. Some examples of registries are registries of copyrights, deeds, wills, motor vehicles and patents. These all have to do with property, not people. Other registries such as registries of births, deaths, marriages, voter registrations, college registrations, and the like all have to do with registering natural people. Now we are going to take a leap. What really is a registry? Generally, a registry applies to vessels in foreign commerce, whereas enrollment refers to coastwise navigation. When we register ourselves, we are saying that we are vessels in foreign commerce. Sounds ridiculous, doesn't it? But that is why our names magically become capitalized on all of the various registrations, military, voting, birth certificates, death certificates, credit cards, etc. This essay presumes that you have an understanding of the all-capitalized, fictional name versus proper names that only have the first letter capitalized. All vessels/ships have capitalized names. After registering, we are no longer dealt with as natural living souls, but as vessels operating in foreign commerce. What is the foreign commerce in which we are operating? Corporate commerce. Corporations cannot do business with natural beings, so we enter their jurisdiction to do business with corporations when we become a vessel, because a vessel is not a natural being. A vessel is a fiction just as a corporation is a fiction, and now the two fictions are capable of transacting business. This all ties in with the flag law we've been studying. Many people for years now have said that we are under maritime law and had us study maritime/admiralty law for court. After all, the flag flown in all of the courts is a military flag, and therefore the law they are advertising by that flag is admiralty. So we are viewed as vessels because we registered as such. We are all vessels in a sea of commerce, and all courts are commercial courts for commercial fictions, not lawful common law courts for real people. Page 1 of 4, Understanding Contracts/Corporations. Page 1 to 4. Okay, now we are a vessel. A vessel enters contracts with other vessels under law of the flag. If we don't like the laws their flag represents, then we do not contract with that other vessel. The flag is your warning of what laws will have control of the contract. When you submit a contract, which is itself a vessel, where is your flag? If your contract does not display a flag, then you are tacitly submitting to the laws of their flag. But you say there is no flag displayed on their contract. Right, and wrong. There is no flag on the face of the contract, but there is a flag somewhere in their building or in front of their building. Every bank displays a United States flag, not an American flag. Most large corporations have the corporate United States flag or the corporate state flag and their company's own corporate flag flying in front of their buildings. Haven't you ever wondered why big corporations have their own flags? These represent the codes, rules, and regulations that govern their contracts. My kids' college is a good example. All three flags fly right in front of the Bible building, for goodness sake. It is astounding how they disclose their intentions, and we haven't a clue as to what is really going on. Again, someone will most likely ask, what is wrong with these flags? Good question, big answer. These flags are for corporations that abide by rules, codes, and regulations, not laws. Allow me an analogy. What corporate name pops into your head when I tell you to think of a LARGE corporation? Okay, keep that big 500 club name in mind during the following analogy. Analogy: after 4 grueling interviews with multiple tests, you finally land that job at the big company. The boss sends you down to human resources to fill out paperwork. One of the forms you must sign is an acknowledgement form for an employee handbook that states you have received, understand, and will abide by the rules, codes, and regulations of the corporation. Some of those rules will deal with dress code, tobacco usage, protocols, harassment, sick time, vacation pay, and even disciplinary actions. Excitedly, you sign the acknowledgement contract and start work bright and early Monday morning. You are in your finest suit with shoes polished, and it's a real good hair day. I, your best friend, show up to take you out for a celebration lunch. I work for myself though, doing landscaping, and I'm in my usual attire, overalls, t-shirt, and work boots. This outfit doesn't meet the standards of the company's dress code, and your co-workers look at me kind of funny, but I do not work for this company, nor did I agree to abide by its dress code, so they cannot tell me how to dress because they have no jurisdiction, no contract with me. Now, what you must understand is that the government is no more than a private corporation. They have corporate codes, rules, and regulations for their corporate employees, just as that big 500 company did in our analogy. Since these codes are not laws, why does everyone follow them as if they were law? Why does the corporate government think you must follow their codes, rules, and regulations? The reason is because you say you are an employee. You state that you are an employee of the United States every time you file a Form 1040 with the IRS, as that form is only for employees. The IRS takes you at your word and treats you as an employee. The same is true for state taxation forms. You also assert that you are a United States corporate employee every time you answer yes to the question, are you a United States citizen? How many times have we done that, maybe 20 or more. Think of all of the forms you have signed that ask that very question: W-4S, I-9S, passports, driver's licenses, job applications, school registrations, credit card applications, Brady Bill forms. The list is endless. United States, corporate, citizens are subject to all of the codes, rules, and regulations of the company. If you claim national citizenship, please remember that America or your state is the nation to claim, not the United States corporation. Personally, I am an inhabitant of Texas and my citizenship is in heaven. The bottom line is that when we are dealing with corporations, we are dealing with contracts. Erie Railroad versus Tompkins J. Just as I did not have a contract with the Big 500 company and did not have to adhere to its dress code, I don't have a contract with the United States corporation, so I don't have to adhere to their employee codes. Everything is by contract. Even the courts are corporations and operate by contract. Everything offered to you either verbally or in writing is a new offer of contract. Think about these examples and start noticing how many times each day you get offers of contracts: a traffic ticket, a parking ticket, a code enforcement violation for your yard not being mowed, a building permit, a jury duty notice, a notice or bill for property taxes, a bill to re-register your car, a notice or bill for state or federal taxes, a notice from your bank or credit card company that there will be higher charges for late payments, etc. The list is eternal because everything between you and a corporation is an offer of contract. The good news is that all contracts can be accepted or rejected. Within a 72-hour period under the Truth in Lending Act, you can reject an offer of contract. This includes rescinding contracts that you accepted and for whatever reason have changed your mind about accepting. What happens when a police officer pulls you over and gives you a ticket? Do you have a choice as to whether or not you are going to sign that ticket? Of course not. Do you even have the choice as to how you are going to sign the ticket? Not anymore. My brother Steve was stopped last week and he called me to ask how he should sign the ticket. Steve was ready when the police officer returned and handed him the ticket, but the officer told Steve to sign his name and only his name. Wow. Forced contracts under threat, duress, and coercion. Is this the land of the free? Page 2 of 4, Understanding Contracts/Corporations. Page 1 to 5. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _contributions, Manuals, Additional _collections. Language English. Item size 138.1 M. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Added date July 13, 2020, 23:01 and 35 seconds. Coverleaf 0. Identifier: The Redemption Manual. Identifier ARC/13960/T0KT5N815. OCR Abbey Fine Reader 11. Scan. The Redemption Manual. Book Reader Item Preview. It's decision time. If we start rejecting all offers of contract that demand money out of our pockets, we will hit them where it hurts. Eventually they will have no choice but to shut their doors, as would any business whose sales have dropped off. The only difference between the corporate government and your local 5 and dime is that you actually get something in return for your money at the local 5 and dime. For those of you that still believe we have to support our government through taxation, I simply point you to Ronald Reagan's Grace Commission report of 1984. 100% of what is collected is absorbed solely by interest on the federal debt and by federal transfer payments. In other words, all individual income tax revenues are gone before one nickel is spent on the services taxpayers expect from government. This country operates today on the same sources of revenue as it did prior to the income tax, duties or imposts on imported goods and excise taxes on domestic goods that are non-essential items. This is all the revenue required to run the government. The next standard objection is a book in itself and requires a good deal of research to understand, but I want to try to briefly answer one more objection that most people of good moral character will raise in regard to the federal debt. That objection/question is, don't we have to pay our debts? If this were an honest debt, that you or I incurred and agreed to pay, then by all means the answer would be an overwhelming yes. However, that is not the case with the federal debt. The federal is the United States Corporation, again, a privately held company that artificially created this outrageous debt and then made you and I believe we were responsible to pay their debts for them. The debt is what the corporate owners created and lent back to their subcorporations. It's not even a real debt, it's fraud, which coincidentally stands for Federal Reserve Accounting Unit denominations. If that big 500 corporation from our analogy came to you and said, "Hey, we need your help in getting rid of our debt," you may feel a modicum of sympathy for the corporation, but would you pay their debts for them? No way. Then why are you paying this private company's artificial and fraudulent debt simply because they titled their corporation United States? The corporate government is nothing more than a pyramid scam leeching off of the hard-working productive sector. Back to my new motto, just say no more. All definitions are from Black's Law Dictionary 6th edition. The following accounts should help you understand the point of this essay. Everything is about contracts. Contract story number 1. In February of 2001, was on my way to visit my mom in New Mexico. She just had emergency surgery and needed someone to look after her. The doctors explained that there were heart complications, so I rushed to her side. I, unfortunately, am the queen of tickets, so now rushing to me equates to 5 miles over the posted limit. The last thing I wanted was to prolong the trip by having a police officer pull me over. But a lesson was in the making, and sure enough, a Texas Highway Patrol had nothing better to do than harass me. He badgered me into telling him why I was in a hurry. He proceeded to verify my story by calling my mother at the hospital, as if she didn't have enough to worry about. She almost lost her life the day before, and then he still writes me a ticket, and not for 5 miles over, but 10. So I write the judge a letter explaining why we don't have joinder, and I ask him to answer a few questions. Without knowing it, I had rejected his offer of contract. I don't show up by the date allowed, so the nice judge writes me a letter of extension and gives me 2 more weeks to appear. I call him and ask him what law he is using to prosecute the case. He doesn't even understand the question, so I say, is it Admiralty, Maritime, Common, Statutory, UCC, what? To which he replies, it's anything I want it to be. Well, that narrows things down, doesn't it? I then ask him if this is a civil or criminal matter, and he says it's both. So now I don't have a clue what law to study in order to fight this, nor do I really understand what I'm being charged under. During this phone conversation, the judge tells me he isn't going to have time to go over all of this in person when I come down. I tell him that I am coming down to fight this and that he may want to have the county attorney help him look over the questions in my letter. He didn't take too kindly to that suggestion. He also said that he didn't even have a flag in his chambers, so not to worry about jurisdiction. Page 3 of 4, Understanding Contracts/Corporations. Page 1 to 6. The day comes to appear in the judge's chambers to talk about the ticket. Wouldn't you know it, there is a tiny flag in the pen holder on the judge's desk. Well, I'll be, no flag, hi. There is also a county attorney that has to be present before the judge will allow my husband and I into his chambers. I begin by holding my flag, handing the judge a 4-page letter and telling him that this is a special, not general, appearance. The letter explains why the court and I don't have joinder. The next 20 minutes is a jurisdictional tug-o-war in which the judge and county attorney try in earnest to let me to plea, including the judge telling me that he is going to enter a plea for me, to which I responded with, "Judge, you can't practice law from the bench." The county attorney finally knows I'm not going to give in, so he asks, "Young lady, do you have a driver's license?" I said, "Yes, sir, unfortunately I do." He then turns to the judge and says, "Judge, she has appeared before you today and she has a driver's license, so she has waived her rights." I waived my rights? You know that light bulb that goes off over the heads of the cartoon characters when they get a great idea? At that very moment, that same light bulb appeared over my head. I realized that it was all about contracts. Thinking quickly, I turned to the judge and asked him to remind the county attorney that I had reserved my rights on the face of the ticket and that I had made a special appearance under threat of imprisonment which in no way waives my rights. The county attorney then asked the judge to grant a continuance so that he could review my 4-page letter. The judge did so and told me to return a month later. I got home and recounted the story for a friend of mine. The friend said, "Oh Ann, you just gave them jurisdiction. Sit down right now and write that judge and tell him you didn't agree to that continuance." I did just that and told the judge that I wasn't coming back on that date or any other date. This letter was a bit different. Instead of asking him to dismiss the ticket, which sounds as if I am granting jurisdiction, I demanded him to immediately cease and desist the proceedings under the color of law against the sovereign. Well, it has been 2 years and no warrants were ever issued for my arrest. Not only did I have 2 insider friends check to see if warrants were put out on me, but I was arrested. Most of the best people are. In December of 2001 on a contempt charge and no outstanding warrants were on my record. The contempt charge is what I got for trying to help a friend in court. Don't go into their con right if yon can help it. I know that sometimes it's unavoidable and even necessary. You are granting jurisdiction just by being there if you don't know exactly how to challenge it. Please don't play their game on their field. They have the home court advantage and the guns to back it up when they feel like it. Contract story number 2. In 1999, one was attempting to help the same friend in story number 1. The city animal control division informed him that he couldn't have all of the animals he was feeding and housing. We, being the good, law-abiding people we are, wrote a letter to the judge inquiring as to how the city's codes could violate the Constitution. There was no response to the letter, so after about a month, we began to inquire as to when a response would be forthcoming. As it turned out, the judge had given the letter to the city attorney and we wound up in her office discussing the matter. My friend asked questions, while I tape recorded the conversation and one of his witnesses testified to the city attorney that animal control had actually gone into my friend's yard and taken some of the animals. The conversation eventually came to the Constitution and flag law. My friend asked what laws the city went by since we believed their codes were in direct violation of the Constitution, at which point the city attorney became visibly upset and practically yelled at my friend. She said, "Mr. Darluck, we go by the City of Abilene laws, the State of Texas laws and the United States laws." As you would assume, we left that meeting in a very confused state. It took more than a year for us to understand what the city attorney had meant by her statement. She said that the city abides by corporate codes. Since corporate codes are all about contract and we all have the right to contract, the city codes do not abrogate the Constitution, but she wouldn't disclose that to us. That is their game, they get you to contract and then you're stuck, unless you know how to reject their offers of contract. Please retrain your thought processes. What you and I were taught was government is nothing more than a privately held corporation. And what you and I were taught were laws are nothing more than corporate codes, rules, and regulations that have nothing to do with living souls unless you work as an employee for that company. Page 4 of 4 Understanding Contracts/Corporations. Page 1 to 7. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _contributions, Manuals, Additional _collections. Language English. Item size 138.1 M. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Added date July 13, 2020, 23:01 and 35 seconds. Coverleaf 0. Identifier: The Redemption Manual. Identifier ARC/13960/T0KT5N815. OCR ABBY Fine Reader 11.0, Extended OCR. PPI 300. Scanner Internet Archive HTML5 Uploader 1.6.4. Comment. Reviews. There are no reviews yet. Be the first one to write a review. The Redemption Manual. Book Reader Item Preview. The True Birth Verified by the Creator God. In order a declaration by affidavit confirming those things most surely believed. Luke 1, 1-4. Now the birth involving Jack Rabbit Patriot was on this wise. At the time appointed. Jack Rabbit Patriot, being legal age, make the following statements and declare that on God's personal word and knowledge, they are true. The time Lie by God was birthed. On the land, Cottontail County, Texas. Jack Rabbit's birth date. Genesis 18, 10-14. Signed accordingly by God's word on Jack Rabbit's birth date. Holy Scripture. Picture. Jack Rabbit Patriot, grantor secured party's signature address. City, state zip code. Jack Rabbit Patriot, agent attorney in fact, autograph. Witness. 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 Page 1-8. American people wake up. Attributed to, if it is not his it is appropriate, Edward Mandell House. Sent by the powers that rule the Demerai commercial government form England, worked with and controlled all the presidents from Woodrow Wilson through Franklin Delano Roosevelt in establishing all that the American people are reaping by slavery, had this private meeting with Woodrow Wilson, 1913-1921, and stated, very soon, every American will be required to register their biological property in a national system designed to keep track of the people and that will operate under the ancient system of pledging. By such methodology, we can compel people to submit to our agenda, which will affect our security as a chargeback for our fiat paper currency. Every American will be forced to register or suffer being able to work and earn a living. They will be our chattel, and we will hold the security interest over them forever, by operation of the law merchant under the scheme of secured transactions. Americans, by unknowingly or unwittingly delivering the bills of lading to us will be rendered bankrupt and insolvent, forever to remain economic slaves through taxation, secured by their pledges. They will be stripped of their rights and given a commercial value designed to make us a profit and they will be none the wiser, for not one man in a million could ever figure our plans and, if by accident one or two should figure it out, we have in our arsenal plausible deniability. After all, this is the only logical way to fund government, by floating liens and debt to the registrants in the form of benefits and privileges. This will inevitably reap to us huge profits beyond our wildest expectations and leave every American a contributor to this fraud, which we will call social insurance. Without realizing it, every American will insure us for any loss we may incur, and in this manner, every American will unknowingly be our servant, however begrudgingly. The people will become helpless and without any hope for their redemption, and we will employ the high office of the president of our dummy corporation to foment this plot against America. Use the redemption process, power of attorney in fact. Be a free man or woman. Page 1-9. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _contributions, Manuals, Additional _collections. Language English. Item size 138.1 m. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Added date July 13, 2020, 23:01 and 35 seconds. Cover leaf 0. Identifier: The Redemption Manual. Identifier ARC/13960/T0KT5N815. OCR ABBY Fine Reader 11.0, Extended OCR. PPI 300. Scanner Internet Archive HTML5 Uploader 1.6.4. Comment. Reviews. There are no reviews yet. Be the first one to write a review. The Redemption Manual. Book Reader Item Preview. A word of warning. There have been many and various people who have used the site drafts, and there have been many and various people who have been tried by the courts and are now in prison. Site drafts or CMOs create debt, and the only debt creator is the Federal Reserve Board/Bank. The UCC gives the Federal Reserve Board wide latitude in making a determination whether an instrument is fraudulent or legal. A sovereign cannot create debt. It is his/her energy that creates payment for the debt created by the Federal Reserve Board/Bank and all their corporations. Stay with the Acceptance for Value program. Not one living soul has been arrested for use and implementation. Reduce the debt. Learn the Acceptance for Value and Affidavit/Denial Corporation's existence and protect yourself, the living soul, in the corporate/commerce world. Page 1 to 10. Flag. Registered mail number. Stamp. With your name signed over the stamp. Understanding the flag. The law of the flag, an international law, which is recognized by every nation of the planet, is defined as a rule to the effect that a vessel is a part of the territory of the nation whose flag she flies. The term is used to designate the right under which a ship owner, who sends his vessel into a foreign port, gives notice by his flag to all who enter into contracts with the ship master that he intends the law of that flag to regulate those contracts, and that they must either submit to its operation or not contract with him or his agent at all. Roostrat v. People, 57 NE 41. Registration. When you register yourself, you record formally and exactly, in a list or the like, with a registrar. A registrar is an officer who has the custody and charge of keeping of a registry or register. What really is a registry? Generally, a registry applies to vessels in foreign commerce. When we register ourselves, we have recreated ourselves as vessels in foreign commerce. Flag. Everything moving in commerce is a vessel. Spaceships, satellites, seagoing ships, planes, buses, automobiles, the mails, persons, and believe it or not, contracts. Just as a ship must fly a flag to designate its nationality/laws of contract, your paperwork needs to display a flag in order to establish who you are and what law you will use to contract. Stamp. All vessels charge a freight fee to deliver their cargo. Likewise, we must pay a freight fee as the authority to deliver our cargo, i.e., the paperwork we send needs to have a stamp on it. The paper is the vessel, the words are the cargo, the flag designates the law, and the stamp shows that we have paid the fee to deliver our cargo. Place the colored flag in the upper left-hand corner as you are looking at the page. The Bonnie blue is what I use, and place a dollar stamp in the upper right-hand corner. Write your autograph over the stamp to cancel it, thus making you the postmaster. Whatever flag you choose to use, remember not to use a Go ID fringed flag, as that is under their jurisdiction and not your common law jurisdiction. Registered. Use registered mail to identify your vessel. This places your document/vessel into international law and gives it recognition in international commerce. This is another assertion that you are in fact foreign to the jurisdiction they are trying to place you under. This number now becomes the case number for any and all paperwork related to the first document sent. Jolly Roger. If you come upon a flag that is not recognized in international law, it is a pirate flag. Anything attached to a Title 4 USC 1(2) flag, i.e., gold fringe, mutilates the flag and under Title 4 USC 3 carries a 1-year prison term. The gold fringe is an added color and represents color of law when placed upon the Title 4 USC flag. The fringe is a mutilation, it suspends the Constitution and establishes color of law. The gold-fringed flag that utilizes color of law and portends to be the American flag is not the American flag of peace. It is a pirate flag, and it is your warning as to whom/what you are about to do business with. Army Regulation 260-10 states that the gold fringe may be used only on regimental colors, the President's flag, for a military courts-martial and for the flags used at military recruiting centers. Courts. the flag in court is the court's advertisement of the laws governing their contracts. If you do not wish to contract with these courts, then jurisdiction must be challenged. In order to correctly challenge jurisdiction, you must remember /G/Rudy versus Logan, 6, Bush Key 8, which states, "It is an elementary rule of pleading, that a plea to the jurisdiction is a tacit admission that the court has a right to judge in the case and is a waiver to all exception to the jurisdiction." Which means that if you plea, you have waived your rights to challenge jurisdiction. And when the judge attempts to enter a plea for you and says that the state statutes allow him to do so, tell him no, that he cannot practice law from the bench and that he is not your attorney and you do not give him permission to act on your behalf. Read the Courts by Contract section in this manual for further information. Page 1 to 11. The Redemption Manual. By Robert D. Sparkman. Publication date 2. The Redemption Manual. Book Reader Item Preview. Lawgiver.org. U.S. Postal Service or the Post Office. You may want to get rid of your mailbox and take the numbers off your house. These signify a commarial address and not your location as a good and lawful Christian man or woman. Since 1863, the military took over control of what once was the post office. General delivery was the only form of mail prior to that time was common to all people. The current U.S. Postal Service, USPS, is in effect today as a corporation under military rule that services only the commercial persona in the field of military occupation. However, the common law post office still exists and general delivery has never been abolished, just hidden. This is why it is imperative that all Christians call for their mail and general delivery at the post office and no longer accept commercial free delivery by the USPS. Let's first get it straight that the God ruling our governments today is the God of commerce, Mercurius. You may know him as Mercury. He is the god of profit and gain, and his fellow god Mars, the god of war, protects Mercury's interest. They were around when Jesus was taken up to a high mountain by the prince and ruler of this world, the boss and king of Mars and Mercury. Our Lord was shown all the worldly nations. The prince of this world tempted Jesus with these nations by saying, "I will give you all this power along with their glory because they have been given to me and to whomsoever I wish to give them to. If you'll worship me, all of this will be yours." Quite a bribe. But Jesus told him, "Get behind me, Satan. It's written that you must worship the Lord your God and only him will you serve." See Luke 4, 5-8. As God's great fallen angel, the worldly prince knew this well. Residents, bar attorneys, individuals, natural persons, corporations, homeowners, homesteaders, officers, trusts, taxpayers, partnerships, directors, IRS 501(c)(3) churches and citizens. All these names are federal and state statute or administrative code defined fictional entities, are addressed by number and street name or P.O. box. These terms do not represent the good and lawful Christian man or woman. You are none of these fictional names in commerce, but once you accept free delivery at an address, you have voluntarily taken on the commercial name or persona addressed in the letter. General delivery to transients or sojourners has never been altered or changed since Lincoln's War. In common law, general delivery is a vested right that cannot be denied to a Christian as long as he is operating outside of commercial free delivery. You cannot be in common law and commercial statute law at the same time. The non-commercial side of the post office still exists as general delivery, where one calls for his first-class mail rather than accepting commercial delivery at an address. Page 1-12. Lincoln instituted commercial free delivery on July 1, 1863. Prior to this time, postal matter was picked up or called for by a patron at his local post office. Notice that customers did not call for their mail, as a customer is a fictional commercial vendee of the vendor, the USPS. When you receive mail by free delivery at your mailbox, you are a commercial customer by implied contract. When you accept free delivery, you accept the benefit of a commercial venue in contract. A Christian cannot be under contract of commercial benefit at the same time he claims to be under the covenant of God. According to the Postal Laws and Regulations of 1932, letters delivered free on post routes are defined as commercial. Gas, electric, water and tax bills or other statements of accounts, orders for merchandise, etc. It's lawfully correct to conclude from this that free delivery is only made through a delivery route and that all free delivered letters on this route are commercial taxes and commercial merchandise. This means that all those who receive their mail at an address or a mailbox are those who are in contract to pay government debt or other debts. General delivery is intended for use primarily at any post office to serve transients and customers not permanently located. The Post Office Domestic Mail Manual at D931.1. The keywords are transients and location. Notice this does not say addressee or address, which are considered commercial terms. As a sojourner in the land of the Lord, you are a transient. The land shall not be sold forever, for the land is mine, for yet are strangers and sojourners with me. Leviticus 25:23. From 1932 until today, the U.S. Postal Service regulations only restrict residents, persons, and customers. A Christian is a sojourner or transient, and there are no restrictions concerning the same. This is why calling for your mail and general delivery is still recognized in common law and is a traditionally vested right that has never been altered, amended, or changed by statute, code, or regulation. To maintain and declare your Christian common law jurisdiction, it is mandatory that you remove yourself from commercial free delivery, remove the mailbox and identification numbers signifying your commercial address, and advise all who wish to send you first-class matter to do so as follows. Brother John Elias, the Ecclesia at Wayne, to be called for in general delivery, Wayne Post Office, Wayne, Georgia State. Page 1-13. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _contributions, Manuals, Additional _collections. Language English. Item size 138.1 m. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's. The Redemption Manual. Book Reader Item Preview. Other publications in this series concerning your Christian appellation and the rules of English grammar will explain why certain letters in the beginning of words are not capitalized, why your given name and surname are written as above, and what periods and bracket signify according to English grammar and the law. Your local postal service may try to tell you that general delivery is only good for 30 days and then it automatically cancels. They may cite sections 1.2 through 1.4 of the manual, see above, which states in part, postmasters may restrict the use of general delivery by customers. But notice this is a customer restriction, not a transient restriction. They will also quote, general delivery customers can be required to present suitable identification before mail is given to them, and general delivery mail is held for no more than 30 days, unless a shorter period is requested by the sender. Subject to 1.2, general delivery mail may be held for longer periods if requested by the sender or addressee. Again, notice that the terms used are restricting the customers and the addressee, both being commercial terms of commercial persona, which does not apply to transients and sojourners. They may ask you to fill out a LISPS form to request general delivery. This is not general delivery through the post office but a commercial customer general delivery request of the USPS. You have no need to request that which is already common to all people and readily available without restriction, hence, being of the common law. Such commercial-oriented request forms are for customers, not transients. Just advise everyone to start sending your first-class mail to you as shown above, then, go to the post office once a week and ask them for mail they may be holding with your name on it in general delivery. They will almost always ask you for identification. Hopefully, you personally know the clerk. Postal Service employees are allowed by postal regulation to hand to you mail without any further identification if you are personally known to them. If not, show them a copy of your baptism in Christ Jesus from the church, signed by Christian witnesses. If they insist on a picture identification, Tell them you simply have no identifications with your picture on it, such as state driver's licenses. Tell them you are a good and lawful Christian who does not receive benefits from the government, including ID cards or licenses. They will most likely presume that you're one of those Quakers or belong to some other religious cult, and they will also be in fear that if they deny you any matter in general delivery, they may be in civil rights trouble, so they'll almost always give you your general delivery matter. The evidence of a mailbox on a house, in front of a house, or a post office box prove military commercial residency as an enemy in the field. A doorbell or door knocker is an invitation under military and statute law to break down the door if necessary within their own discretion, because it is presumed that the existence of such is to permit or allow anyone to enter for any reason once announcement has been made and without any further protocol necessary to gain entrance. Page 1 to 14. The Jurisdictional Trap of Free Home Delivery. Contributed by Greg Lauren Durand. The principal tool used by the United States government to establish the people as residents of the one of its de facto appendages is the benefit of free city or free rural delivery of mail. As was stated recently by Associated Press writer Calvin Woodward, 1863 was the advent of numbered addresses. Before, people went to the post offices for mail addressed only by name and city general delivery. Even more revealing is the following quote from Congressman Clyde Kelly, who served in the early 1930s as a member of the Post Office and Post Roads Committee in the House of Representatives. Free delivery is a phrase born of the service policy of the Post Office. It has been growing in meaning until it is clearly established that every American who mails a letter is entitled to have it delivered to the doorway of the addressee. Under the self-sustaining policy of the early days, letter carriers were authorized at the larger post offices and were allowed a fee of 2 cents for each letter, to be paid by the person to whom it was addressed. If he did not have the fee, the letter was returned to the post office, to await his call. Such a system could not endure, once the true purpose of the post office to regulate citizens was realized. On July v/1863, free city delivery service was instituted as a war measure to keep track of public enemies and suspects. Northern Democrats. Still more eloquent testimony to the service ideal of the post office is found in the rural free delivery. It might be argued that it would be more economical to deliver mail in congested cities than to provide storage space in general delivery for mail awaiting the calls of patrons, not customers or residents, but no such reasoning will apply to smaller towns from which most of the rural routes radiate. There never was any other motive than the public welfare behind the establishment of the rural free delivery service. The one test in changes in routes must be, will the service be as good or better than formerly? The test of self-support should not determine the future of this facility, which brings benefit to every citizen of the United States, whether he lives in city or country. It is the highway of service, designed by a democracy with faith for a social institution of vital importance in a people's nation, Lincoln's new nation. Every American is the beneficiary of this postal highway and of those leaders, the Lincoln administration and all its successors, who insisted upon its being built on the service foundation. Its very existence is proof that the true objective of the post office is service, not money-making, either for profit or exactly balancing expenditures. It is more essential for the protection of the nation, the corporate United States, than the Army or Navy. It is the democratic instrument of a democracy, not a republic. 2. Page 1 to 15. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _ Contributions, Manuals, Additional _ Collections. Language English. Item size 138.1 M. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for the Redemption Manual. Book Reader Item Preview. One needs to be able to read between the lines when perusing government admissions. The benefit that was offered to the American people by the Post Office under Lincoln in 1863, and now by the United States Postal Service, is that Post Office registered enemy aliens. 3. It is important to understand that the United States Postal Service is an independent establishment of the executive branch of the Government of the United States. 4. Consequently, maintaining a plea of residency by receiving mail at an address automatically transmutes the recipient of the benefit into as asset of the occupying power. 1. Calvin Woodward, article, What's in a Number? Modem Digital Confusion. The East Side Journal, Bellevue, Washington, 11 Mary 1997, page A9. 2. Clyde Kelly, United States Postal Police, New York, New York, D. Appleton and Company, 1931, pages 108, 111, 112118. 3. Gerald Coleman, The Post Office Department, New York, New York, Frederick A. Prieger, Publisher, page 81. 4. Title 39, United States Code, Section 201. Page 1 to 16. No zip codes. Use invokes federal jurisdiction. Author unknown. Use of the zip is voluntary. See Domestic Regulations. CD on 122.32 as amended. You should also know that the Postal Service is not discriminate against the non-use of the zip code. See Postal Reorganization AET, CD on 403, Public Law, 91 to 375. The federal government utilizes the zip code to prove that you reside in a federal district of the District of Columbia. This is why the IRS and other government agencies, state and federal, require a zip code when they assert jurisdiction by sending you a letter. They claim that this speeds the mail, but this is a sly and subtle trick. It is also prima facie evident that you are a subject of Congress and a citizen of the District of Columbia who is resident in one of the several states. The receipt of mail with a zip code is one of the requirements for the IRS to have jurisdiction to send you notice. The government not bill a citizen of Texas, because he is not within the purview of the municipal laws of the District of Columbia. In fact, the Internal Revenue Service has adopted the zip code areas as internal revenue districts. See the Federal Register, Volume 51, Number 53, Wednesday, Mary 19, 1986. You must remember that the Postal Service is a private corporation, a quasi-government agency. It is no longer a full government agency. It is like the Federal Reserve System, the Internal Revenue Service, and the United States and the United States Marshal Service. They are all outside the restrictions of the federal Constitution, as private corporations. They are all powerful in their respective areas of responsibility, to enforce legislation for the federal debt. So, if you are using a zip code, you are in effect saying openly and notoriously that you do not live in the state of Texas, but instead are a resident in the Texas area of the District of Columbia, a federal district. There are some so-called patriot groups that either patriots for money. They advocate the use of Title 42 suits, we are for federal citizens only, send mail to you with a zip code, and ask you to do things that please you within the municipal jurisdiction of the District of Columbia. Remember, these individuals may be agents of the government or, even worse, are advocating a one-world government by the use of the Social Security number and the zip code. So you must be aware of the movement towards a one-world government through annihilation or elimination of state citizens by use of the so-called 14th Amendment and its related laws. It is this writer's opinion, both as a result of study, e.g. of page 11 of the National Area Zip Code Directory, of 26 U.S.C. 7621, of CD on 4 of the Federal Register, Volume 51, Number 53, of TDO 150-01, of the opinion in United States v. LaSalle National Bank, 437 U.S. 298, 308, 98, 5 CT 2D 2357, 571. Ed 2D 221, 1978, of 12 U.S.C. 222, of 31 U.S.C. 103, and as a result of my actual experience, that a zip code address is presumed to errata a federal jurisdiction or market venue or revenue districts that override state boundaries, taking one who uses SUA modes of address outside of a state venue and its institutional proceedings and into an international, amiral venue involving Admiralty Eonirns of the United States, we is a amiral operation domiciled in Washington, D.C. Page 1 to 17. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. The Redemption Manual. Book Reader Item Preview. More specifically, looking at the map on page 11 of the National Zip Code Directory, e.g. at a local post office, one will see that the first digit of a zip code defines an area that includes more than one state. The first sentence of the explanatory paragraph begins. A zip code is a numerical code that identifies areas within the United States and its territories for the purpose of CF 26 CFR 11-1, c. Note the singular possessive pronoun its, not their, therefore carrying the implication that it relates to the United States as a corporation domiciled in the District of Columbia, in the singular sense, not in the sense of being the 50 states of the Union, in the plural sense. The map shows all the states of the Union, but it also shows D.C., Puerto Rico, and the Virgin Islands, making the explanatory statement literally correct. Properly construed, zip codes can only be applicable in federal territories and enclaves that may be located within the 50 states of the Union and to the United States and District of Columbia and its territories, cf. Pickaway Bank v. Knoop, 6 Ohio 342, 404, 1856, and U.S. v. Butler, 297 U.S. 1, 63, 1936, to the effect that in every state there are two governments, the state and the United States. Therefore, zip code address are for the corporate United States and its agents, for example, a customs and duty collector at New York Harbor, when they move out into the states of the Union to perform functions delegated to the United States by the national/federal Constitution, or the Texas Department of Transportation, Bureau of Motor Vehicles, or a U.S. congressman. But, by propaganda, misleading information and seditious syntax, government has gotten nearly everyone in the 50 states of the Union to use zip codes of address, and that creates a presumption or a prejudicial admission that one is in such a federal venue, or that one is such a government agent. In general, it is well settled in law that income tax statutes apply only to corporations and to their officers, agents, and employees acting in their official capacities, e.g. from Colonial Pipeline Co. v. Tragle, 421 U.S. 100, 44 L.ed 2D.L, 95 S.ct 1538, 1975. However, all income tax statutes apply only to state-created creatures known as corporations no matter whether state, local, or federal. Since corporations act only through their official capacities, but not as individuals. This is the real purpose for identifying numbers 26 SAR 30 I.6 I09 I, D, and G, and 26 USC 6331, A, and 26 SAR 30 I.6 33 II, Part 4. Use of a zip code address is tantamount to the admission of being a citizen of the United States who does not necessarily have the protections of the first 8 amendments to the Constitution, in the Bill of Rights, when proceeded against by federal or state authority. Maxwell v. Dow, 176 U.S. 581, 20 SCT 448, 1900, but all the provisions of the Constitution look to an indestructible union of indestructible states. Texas v. White, 7 Wall 700, U.S. v. Cathcart, 25 E. Case number 14756, in re. Charge to grand jury, 30 E. Case number 18273, 65 CJ Section 2, not known to be overturned. Page 1 to 18. Sample letter. To whom it may concern. Please kindly correct your records to show that I am located at Non-Domestic C/02819, Bluedo Street, Dallas, Texas. Zip code exempt, DMM 122.32, as amended. Since the use of zip codes is voluntary, see Domestic Mail Service Regulations, Sections 122.32, the U.S. Postal Service cannot discriminate against the non-use of zip codes, pursuant to the Postal Reorganization Act, Section 403, Public Law 91-375. The federal government attempts to assert jurisdiction by sending letters with zip codes, when jurisdiction would otherwise be lacking. The receipt and acceptance of mail with zip codes is one of the requirements for the Internal Revenue Service, in particular, to have jurisdiction to send notices. In fact, the IRS has adopted zip code areas as internal revenue districts. See the Federal Register, Volume 51, Number 53, for Wednesday, March 19, 1986. The federal government cannot bill a Texas state citizen because such a citizen is not within the purview of the District of Columbia, its territories, possessions, or enclaves. As a group, these areas are now uniquely and collectively identified as the Federal Zone, as explained in the book entitled The Federal Zone, Cracking the Code of Internal Revenue, San Rafael, Account for Better Citizenship, 1992. Your immediate cooperation in this matter will be most appreciated. Signed with explicit reservation of all of my rights and without prejudice to any of my rights. John Q. Doe, Agent. John Quincy, Doe, State Citizen. Non-resident alien with respect to the Federal Zone D.C., its territories, possessions, and enclaves. July 19, 02 John Quincy. Page 1-19. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _contributions, Manuals, Additional _collections. Language English. Item size 138.1 m. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Added date July 13, 2020, 23:01 and 35 seconds. Cover leaf 0. Identifier: The Redemption Manual. Identifier: ARC/13960/T0KT5N815. OCR Abbey Fine Reader 11.0, Extended OCR. PPI 300. Scanner Internet Archive HTML5 Uploader 1.6.4. Comment. Reviews. There are no reviews yet. Be the first one to write a review. The Redemption Manual. Book Reader Item Preview. Federal Children. Are we owned by the government? In 1921, the Federal Shepard-Towner Maternity Act created the birth registration, or what we now know as the birth certificate. It was known as the Maternity Act and was sold to the American people as a law that would reduce maternal and infant mortality, protect the health of mothers and infants, and for other purposes. One of those other purposes provided for state agencies in overseeing of its operations and expenditures. What it really did was create a federal birth registry which exists today, creating federal children. This government of parents patrie now legislates for American children as if they are owned by the federal government. Through the public school enrollment process and continuing license requirements for most aspects of daily life, these children grow up to be adults indoctrinated into those things necessary to carry our activities that exist in what is called a free country. Before 1921, the records of births and names of children were entered into the family Bibles, as were the records of marriages and deaths. These records were readily accepted by both the family and the law as official records. Since 1921, the American people have been registering the births and names of their children with the government of the state in which they are born, even though there is no federal law requiring it. The state tells you that registering your child's birth through the birth certificate serves proof that he/she was born in the United States, thereby making him/her a United States citizen. For the past several years, a Social Security number has been mandated by the federal government to be issued at birth. The Social Security number is one of those other purposes. It serves as a means of lifelong tracking of the one whose name is on the birth certificate. In 1933, the United States of America, corporate government, was declared bankrupt by President Roosevelt. The governors of the then 48 states pledged the full faith and credit of each of their states, including the citizenry as collateral, for loans of credit from the Federal Reserve System. To wit, lulleth and credit the clause of the U.S. Constitution, Article 4, Section 1, which provides that the various states must recognize legislative acts, public records, and judicial decisions of the other states within the United States. It requires that foreign judgment be given such faith and credit as it had by law or usage of state of its origin. That foreign statutes are to have force and effect to which they are entitled in home state. And that a judgment of record shall have the same credit conclusive and obligatory force in other states as it has by law or usage in the state from whence taken. Black's Law Dictionary, 4th edition and 6th edition, page 672, cites omitted. After receiving the information of live birth and other particulars for the birth certificate accompanied by the assigned Social Security number, the state claims an interest in every child within its jurisdiction. The state will, if it deems it necessary, nullify your parental rights and appoint a guardian, trustee, over your children. The subject of every birth certificate is a child. The child is a valuable asset which, if properly trained, can contribute valuable assets provided by its labor for many years. It is presumed by those who have researched this issue, that the child itself is the asset of the trust established by the birth certificate, and the Social Security number is the numbering registration of the trust, allowing for the trust's assets to be tracked. If this information is true, and we believe it is, our children are owned by the state. Each one of us, including our children, are considered assets of bankrupt United States corporation. We are now designated by this government as human resources bomb in a delivery room, delivered to the state of birth by way of the birth certificate, for which our mother, provides the requested information including the name and Social Security, or tracking, number wherewith this bankrupt government is supplied with new crop of collateral bomb each year. Page 1 of 3 Federal Children. Page 1 to 20. In 1923, a suit was brought against federal officials, corporation, charged with the administration of the Maternity Act, who were citizens of another state, to enjoin them from enforcing it, wherein the plaintiff averred that the act was unconstitutional, and that its purpose was to induce the states to yield sovereign rights reserved by them through the federal Constitution's 10th Amendment and not granted to the federal government, and that the burden of the appropriations falls unequally upon the several states held that, as the statute does not require the plaintiff to do or yield anything and no burden is imposed by it other than that of taxation, which falls not on the state but on its inhabitants, who are within the federal as well as the state taxing power. The complaint resolves down to the naked contention that Congress has usurped reserved powers of the states by the mere enactment of the statute, though nothing has been, or is to be, done under it without their consent. Commonwealth of Massachusetts v. Melton, Secretary of the Treasury, et.al., Frothinsham v. Mellon, Secretary of the Treasury, et.al. Mr. Alexander Lincoln, Assistant Attorney General, armed for the Commonwealth Massachusetts. To wit: 1. The Act is unconstitutional. It purports to vest in agencies of the federal government, a corporation, powers which are almost wholly undefined, in matters relating to maternity and infancy, and to authorize appropriations of federal funds for the purpose of the Act. Many examples may be given and were stated in the debates on the bill in Congress of regulations which may be imposed under the Act: the forced registration of pregnancy, government prenatal examination of expectant mothers, restrictions of the right of a woman to secure the services of a midwife or physician of her own selection, all are measures to which the people of those states which accept its provisions may be subjected. There is nothing which prohibits the payment of subsidies out of federal appropriations. Insurance of mothers may be made compulsory. The teaching of birth control and physical inspection of persons about to marry may be required by Section 4 of the Act. The Children's Bureau is given all necessary powers to cooperate with the state agencies in the administration of the Act. Hence it is given the power of assist in the plans submitted may provide. As to what those plans shall provide, the final arbiters are the Bureau and the Board. The fact that it was considered necessary in explicit terms to preserve from invasion by federal officials the right of the parent to the custody and care of his child and the sanctity of his home shows how far-reaching are the powers which were intended to be granted by the Act. The Act is invalid because it assumes powers not granted to Congress and usurps the local police power. McCulloch v. Maryland, 4 Wheat. 316, 405. United States v. Cruikshank, 92 U.S. 542. 549 to 551. In more recent cases, however, the court has shown that there are limits to the power of Congress to pass legislation purporting to be based on one of the powers expressly granted to Congress, which in fact usurps the reserved powers of the states, and that laws showing on their face detailed regulations of matter wholly within the police power of the states will be held to be unconstitutional although they purport to be passed in the exercise of some constitutional power. Hammer v. Dawson-Yart, 247,259 U.S. 44. The Act is not made valid by the circumstances that federal powers are to be exercised only with respect to those states which accept the Act, for Congress cannot assume, and state legislatures cannot yield, the powers reserved to the states by the Constitution. A message of President Monroe, May 4. 1822, 4 Elliott's Debates p. 525, Pollard's Lessee v. 5. Hassan, 3 How. 212, Escanaba vx. Chicago. 107 U.S. 678, Coyle vx. Oklahoma, 221 U.S. 559, Cincinnati v. Lau Civilly and Nashville R.R. Co., 223 U.S. 390. Page 2 of 3 Federal Children. Page 1 to 21. The Redemption Manual. By Robert D. Sparkman. Public. The Redemption Manual. Book Reader Item Preview. 2. The Act is invalid because it imposes on each state an illegal option either to yield a part of its powers reserved by the 10th Amendment or to give up its share of appropriations under the Act. A statute attempting, by imposing conditions upon a general privilege, to exact a waiver of a constitutional right, is null and void. Harrison v. St. Louis and San Francisco R.R. Co., 232 U.S. 318, Terrell v. Burke Construction Co., 257 U.S. 529. 3. The Act is invalid because it sets up a system of government by cooperation between the federal government, a corporation, and certain of the states, not provided by the Constitution. Congress cannot make laws for the states, and it cannot delegate to the states the power to make laws for the United States. In re. Rebrere, 140 U.S. 545, Knickerbocker ISCO vs. Stewart, 253 U.S. 149, Opinion of the Justices, 239 Massachusetts 606. The Maternity Act was eventually repealed, but parts of it have been found in other legislative acts. What this act attempted to do was to set up sovereignment by appointment, run by bureaucrats with re-delegated authority to tax, which is in itself unconstitutional. What was once declared unconstitutional by the Supreme Court of this nation in the past should be upheld in a court challenge today. The Constitution has not changed. What has changed is the way this government views human life. Today we are defined as human resources, believed to be owned by the government. The government now wants us, as individuals, to be tagged and tracked. Government-mandated or legislated national ID, which is unconstitutional. Federal jurisdiction to legislate for the several states does not exist and could never survive a court challenge as shown above. Ryden's letters.
What's up?
Not much. How you doing?
I'm okay.
I told you I would call you today and say you would help me to write some letter or the other because I can't go to court on the 10th.
Okay. Yeah, so, alright, one second now. I was listening to something. What was this thing? Where's the pause button?
You want me to call you back Thursday?
No, hold on. Just I'm just trying to pause something. This damn thing. Yeah. It says it's hold on, Marie.
To elected public servants will not save us when we all know their agenda does not include serving those who placed them in power, servitude. Perhaps the 10th Amendment of the Federal Constitution guaranteeing states' rights will, if challenged, when making it known that we as individuals of the several states will not be treated as chattel of the U.S. government. If the federal government believes that they own us, and as such have the right to demand national ID cards, and health ID cards, which will in truth tag us as we tag our animals, then let them bring forth the documents to prove their authority to legislate for it. If our God-given rights to life, liberty, freedom, and pursuit of happiness, which were the foundation upon which this nation was created, do not exist, and liberty and freedom is only an illusion under which the American people suffer, then let the sovereignment of this nation come forward and tell the people. But if we are judged free, then we should not have to plead or beg before our elected public servants to be treated as such. If, in truth, we are not free, then perhaps it is our duty to address this issue forthright and forthwith with the power of the pen and pray the people will waken from their fear and slumber induced by greed. Page 3 of 3 Federal Children. Page 1 to 22. Section 2, The American Dream Through Redemption. Description page 1 The American Dream 2 to 2. 2 The American Dream, Where Did It Go? 2 to 3. 3 Steps Taken for Redemption 2 to 6. 4 Redemption History 2 to 7. 5 Redemption Definitions 2 to 8. 6 Redemption, Why, How, When, Where 2 to 9. 7 Emergency RUEE Summary 2 to 12. 8 Instruments Signed for Accommodation UCC 3-419 2 to 14. 9 Private v. Pubike 2 to 15. 10 The Money Order for GOED 2 to 17. 11 Executive Order of April 5, 1933 2 to 18. 12 The Promissory Note to Pay Our Debts 2 to 21. 13 Pubike PSE Or 192 2 to 22. 14 Prepaid 2 to 23. Page 2 to 1. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage Public Domain Mark 1.0. Topics The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, corporate title, conspiracy theories, natural person, artificial person. Collection manuals _ contributions, manuals, additional _ collections. Language English. Item size 138.1 M. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Added date July 13, 2020, 23:01 and 35 seconds. Coverleaf 0. Identifier The Redemption Manual. Identifier ARC/13960/T0KT5N815. OCR ABBY Fine Reader 11.0, Extended OCR. PPI 300. Scanner Internet Archive HTML5 Uploader 1.6.4. Comment. Reviews. There are no reviews yet. Be the first one to write a review.
This place is talky bubble. What's the one the place like pig pen so? Jesus. Shit. This I forgot to put on
The Redemption Manual. Book Reader Item Preview. The American Dream.
Exactly.
The author's view from an understanding for the material that has EOME from many varied and research material from many and varied patriots and books written by people reading history as they viewed it at the time history took place. Books are never all factual and sometimes are purposefully slanted by the views put forth by the author. There are always errors in understanding in books, but most authors take offense at having something pointed out that was written wrong either for purpose or by mistake. This book is written, it is yours when in your possession, the material is free, change whatever you like in your book, you will not offend me. Page 2-2. The American Dream, where did it go? March 9, 1933, a day that will go down in history in infamy, spoken on a different day but applies more surely for this day, by Franklin Roosevelt. For on this day, by the Trading with the Enemies Act and the declaration of bankruptcy by the Congress for the United States, a corporation, the American dream turned into a nightmare. At this point in history, slowly but surely, the bankers proceeded by taking over the federal court system. The taking over of the American court system is now complete, as the federal rules can be used in state courts. Congress having never lawfully assembled, after Abraham Lincoln dissolved Congress after the Southern states walked out during the debate over the Civil War, and having never been passed into positive law, now sits outside the Constitution, just as the court system does. This is the reason for the voting registration. For registering, you are given the privilege of voting, and anyone who signs and votes in the federal elections, or any election, are voting as corporate entities, and you are agreeing that Congress has the authority to act from a foreign jurisdiction. The entire court system is now ruled by and comes under the foreign jurisdiction flag. It has a gold rope, a gold fringe around the edge, a gold eagle or gold symbol on top the flag, and now some courts will make a mockery for the United States flag by the positioning in a vertical slope. The powers knew that all commerce is ruled by the EO of contracts, better known as the UCCEO. Where there is no contract, there is no case. The teaching began in school that any contract you signed is a valid contract and that you must fulfill it. This is a good saying as long as it is between two living souls, with all the contract revealed for both parties, and the signatures of both parties thereto. The heretical saying, good credit is the most important thing that you have. A valid contract has 4 parts: 1. Offer, 2. Consideration, 3. Acceptance, 4. The signatures by all parties for the contract. Only the parties that have signed the contract can enforce fulfilling the contract. Without the consent by both parties, a lawyer cannot settle any dispute that may arise from a lawful contract. Our Creator created man. The Creator gave man the right forming government. Man gave government the right for forming corporations. As man has no right nor the ability for ruling his Creator, the government has no right or the ability for ruling its Creator. An illusion is used by the democracy corporate government, and gave man a corporate name and made him a legal fiction by writing his name in all capitals with the middle name only an initial. The proper name for a living soul is written in upper and lower case letters, the first and middle name being the sovereign name and the last name is the family name. The real name for a living soul is I, me, my, or myself. Government, being a creation of mankind, is only a piece of paper. As the government, being a piece of paper, could only create a corporation, which in itself is only a piece of paper, neither being able to sign a lawful contract with a living soul. As all governments are corporations themselves, they do not have the ability to sign a lawful contract, for whomever would be so brave, make themselves liable for the execution of the contract, thereby losing their limited liability to prosecution for breach of contract. All corporations then must have someone to speak for them, and the government came up with their own solution. The EOIR, who has been appointed to speak for all corporations in the courts they have created. Page 2 to 3. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _ Contributions, Manuals, Additional _ Collections. Language English. Item size 138.1 M. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Added date July 13, 2020, 23:01 and 35 seconds. Coverleaf 0. Identifier: The Redemption Manual. Identifier ARC/13960/T0KT5N815. OCR Abbey Fine Reader 11.0, Extended OCR. PPI 300. Scanner Internet Archive HTML5 Uploader 1.6.4. Comment. Reviews. There are no reviews yet. Be the first one to write a review. The Redemption Manual. Book Reader Item Preview. The government then came up with a solution to the lawful contract, and it is called the unilateral contract, or a one-signature contract. In their own description of the unilateral contract, it says that they were probably written up by a lawyer or a group of lawyers to commit fraud with the intent to extort monies from the signers. The lawful problem with these contracts, aside from the fact that they only have the signature of one party to the contract, is that they have many hidden traps to which the party is not aware of its contents. In many cases, such as bank contracts of signatures for checking purposes, the contract is never shown to the depositor. All contracts pertaining to corporations signed by a one-party participant are fraud from their conception and are used to extort monies from the people. They cannot be enforced except with our permission or consent by assent. From the beginning of mankind, they have the right to contract with whomever or whatever they so choose. The government then set their court system apart from the Constitution and its people and then invites the people to contract with their court system under the foreign jurisdiction flag, to allow them to settle their disputes. Of course, since a person to the government is described as a corporation, they then treat any living soul, who contracts with their court system as a corporation and they are a legal person, a slave, or debtor and cannot speak for itself. The first thing that crosses the minds of parties when receiving a letter from a lawyer, attorney, counselor, esquire stating you have been sued is to run to the phone, call another lawyer, attorney, counselor, esquire to settle the dispute for the two corporations in their court. The judge protecting the lawyers, attorneys, counselors, esquires, and they in turn protect the court for they are officers of the court. The system is called a legal system, meaning it is legal what they are doing. Legal meaning, with your consent. After gaining your consent it then becomes lawful in their court system for whatever they choose to do to you. EO or lawfulness is constitutional in subject matter for no EO can be enacted, or supposed to be, without an enabling clause from the Constitution of the state or the United States of America. The court does not have a contract with a party until the party gives the judge his/her name. Until that time, the judge is merely an actor in a black robe. The contract the court is trying to get with party is to contract the party under the foreign jurisdiction flag. See chapter on the flag in the court. As the judges do not file their oath of office into their courtroom, thereby acting under administrative EO whatever they want it to be. The EOs passed since 1926 have all been signed by the President for the British Accredited Regency, Bar, from the state of New York, making all laws come under the bar, so they are nothing more than bar codes, rules, regulations, statutes, procedures for the corporations to follow. The only way you have of making the judge uphold his oath is to file it into the case and restrict him to the law that you want to follow. There are 7 demands for discovery questions to ask all lawyers, attorneys, counselors, esquires. 1. Please produce the legislative act and its implementing regulations that precipitated this cause. 2. Please produce the legislative act that created the office of lawyer, attorney, counselor, esquire. Please give me the address of this office where I may go and get a license for practicing EO. 3. Please produce a copy of your oath of office as an officer of the court and where you filed it into public record. 4. Please produce the contract signed by myself, proper name of the living soul, and you, name of the lawyer, in which I agreed to give up my constitutional rights. 5. Please give me your name, address, and phone number. 6. Please give me your bond number and your bonding company. 7. Please send to me an acknowledgement that you understand that you have perjured your oath of office and are committing constructive treason against the Constitution of the United States of America, the state of Texas and the American peace flag. Page 2-4. Under this system of consent, a living soul never has to accept the ruling of the court, but they must object at all times to the action being taken. All persons spending time in prison were sent there by their own words. They did not ask for allocution. Example, Judge, did you receive a fair trial? Answer. Yes, the party is just being railroaded. Did your lawyer fight hard for you? Answer. Yes. Do you feel that 12 years is a reasonable sentence? Answer. Yes. They have just sentenced themselves to prison. This is aided and abetted by the party's lawyer, who has told the party to be nice to the judge in the sentence phase of his trial and tells the party that he/she understands the judge is going to probably give him a 12-year sentence instead of the 50 he could get. The other part of the problem is with the laws, or in today's court the total lack of laws. The charge and intent are lumped together in one charge and you then cannot plead innocent, you must plead guilty, not guilty, no contest, thereby giving the court jurisdiction. All the courts have been lumped together into one court, administrative/admiralty and civil, contract/commerce. With the advent of your plea you go under administrative, any law they want to use to convict you. In order for a law to be construed as law it must have an enacting clause from the source the law came from, i.e. king, legislature, etc. All laws proceeding from the state legislatures must have an enacting clause, be it enacted by the legislature of the state of Texas. A legislature can only introduce a bill, it cannot introduce a law. It must go through, be approved unanimous by the House, signed by the leader of the House, be approved by the Senate, signed by the leader of the Senate, approved and signed by the governor, and the bill becomes law. Now it is checked against the Constitution to find the enabling clause from it was written. If the Constitution does not allow for the law, then it is void from its inception. Have you ever heard a party can challenge the enacting part of the law or the subject matter jurisdiction of the matter he or she is being tried for violating at any time of the trial or upon conviction, while in prison? Usually it is not a law a party is being tried for breaking, but a code, rule, or regulation, or breach of contract. The proper response to you have been sued is the redemption process or rejection, returning their contract unsigned in full accord with truth in lending. Never let an attorney or lawyer send you any document without accepting it for value or rejecting, returning without a signature in full accord with truth in lending. They may say anything to you in their first letter and you may think it is harmless. A rattlesnake seems harmless and makes a pretty noise, but is deadly when it strikes. Have you ever heard the phrase, "You don't need to respond"? Do not believe it. Respond with the redemption process or reject, return without a signature in full accord with truth in lending. Don't contract with third parties, tell them to get lost. Tell them that they are lured. We now understand that the government gains power of attorney over us when we are born, and they take our birth certificates and make negotiable instruments out of them. We now know that through the Social Security Administration and the issuance of the number, we are recorded as a trust, and the living soul is made the trustee of the strawman the trust created. We now have our own power of attorney in fact, and we now know which form to fill out for taxes. We have already won. Page 2 to 5. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _ Contributions, Manuals, Additional _ Collections. Language English. Item size 138.1 m. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Added date July 13, 2020, 23:01 and 35 seconds. Coverleaf 0. Identifier: The Redemption Manual. Identifier ARC/13960/T0KT5N815. OCR Abbey Fine Reader 11.0, Extended OCR. PPI 300. Scanner Internet Archive HTML5 Uploader 1.6.4. Comment. Reviews. There are no reviews yet. Be the first one to write. The Redemption Manual. Book Reader Item Preview. Steps taken for redemption. Step 1. Read all papers concerning redemption, especially read and reread public vs private. Step 2. Fill out and file your UCC-1 and the security agreement for the STRAWMAN, a transmitting utility, and do all other documents. Step 2. Remove yourself from the voter's registration with the enclosed form. Step 4. Accept for value any document that purports placing the obligation from the government for you. Step 5. Write across their original document sent for you the acceptance for value statement. Step 6. All letters are in the book that you will need. Step 7. Send back the original document with your letter, UCC 3-419, HJR 192, Power of Attorney in fact. Step 8. Make out your bill of exchange. Example is included. A. Invoice number is the first letter of your three names: Jack Rabbit, Patriot JRP, plus date May 21, 2001, 052101, and bill of exchange number. Example JRP 052101 BOEIUI. B. Posted certified account number, certified mail number used for mailing for Treasury. C. Account number, first letter of your three names: Jack Rabbit, Patriot JRP /UCCI number issued by the state, date May 21, 2001 and case number or document number. Example, JRP 052101/UCCL00898745-3-95 Civ 199G. D. Debtor and location person bill of exchange is for an address. E. Value of bill, whatever you make it, should be substantial, let your imagination run away. F. Sign as creditor for the strawman include your power of attorney in fact. Step 9. Any additions for the UCC-1 is made through the UCC. 3. Step 10. Any action or case taken after the filing of the UCCI must be filed on the UCC. 3. Step 11. Any bill of exchange written as an acceptance for value result must be registered on the UCC. 3. Step 12. Mail bill of exchange stamped original to Secretary of the Treasury and wait 10 days, then mail debtor and location a bill of exchange stamped copy. Use examples in the book. Page 2 to 6. Redemption history. There have been so many papers written about the redemption process and yet there seems a lack for understanding the basic concepts. Redemption was the initial path taken by people who know they are free but see no hope in the judicial system as it is practiced. It is vitally important for understanding how the people in the government turned our lives upside down and have made us believe that we are subject under them, when in reality they are subject under we the people. Every being is part and partial for we the people. The important points. 1. In 1871 the federal government formed itself into a corporation and pulled itself from under the Constitution. 2. In 1913 the Federal Reserve central banks were created. 3. In 1933 President Roosevelt put into effect the Trading with the Enemies Act. This applied only for federal citizens. 4. In 1933 President Roosevelt took the gold away from the people although they were not required for giving it away, thereby leaving the people without money or paying debts with. 5. In 1933 President Roosevelt passed H.J.R. 192 June 5, 1933. Simply put, since the government had taken the gold, the people had no money, the government would pay the debts for the people dollar for dollar, thereby giving the people unlimited credit. 6. In 1938 Erie Railroad vs. Tompkins made contracts the rule in our courts. 7. In 1946 we lost our government and courts through the Administrative Procedures Act. 8. In 1965, silver was taken away as a means for paying debt. The UCC became the supreme law for America concerning the banking system. The courts were pulled together in administrative/admiralty and civil, contract or commerce/corporation, and the act and intent were brought together, thereby taking away your plea of innocent. You had to prove there was no intent. Guilty until proven innocent, changing the often quoted, you are innocent until proven guilty. Page 2 to 7. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _contributions, Manuals, Additional _collections. Language English. Item size 138.1 M. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Add date July 13, 2020, 23:01 and 35 seconds. Cover leaf 0. Identifier: The Redemption Manual. Identifier ARC/13960/T0KT5N815. OCR ABI Fine Reader 11.0, Extended OCR. PPI 300. Scanner Internet Archive HTML5 Uploader 1.6.4. Comment. Reviews. There are no reviews yet. Be the first one to write a review. The Redemption Manual. Book Reader Item Preview. Redemption Definitions. From Zondervan's Pictorial Encyclopedia for the Bible. Redemption. Redemption is deliverance from the power for e'en dominion and the enjoyment for resulting freedom. It involves the idea of restoration for one who possesses a more fundamental right for interest. The best example for redemption in the Old Testament was the deliverance for the children for Israel from bondage from the dominion for the E'en power for Israel. From the expanded Vine's expository dietitianary for New Testament words seems it supports Zondervan with this definition for redemption. A. In the natural sense for delivering, Luke 24:21, for setting Israel free from the Roman yoke. Redemption. In referee for the United States is capturing the strawman, the transmitting utility from the natural living soul for the corporation or commercia, a third party using a state birth certificate, with an all capiti name, a fiction, appearing as your name given at birth with you, the natural person, as the pledge for your energy and surety for any charge made against the strawman. Freedom comes with the filing the UCC-ICM against the strawman and the subsequent acceptance for via for the state birth certificate for the governor in the various states for the union, thereby making him/her the surety and guarantor for any action against the strawman. Page 2-8. Redemption, why, how, when, where. Long before the States United of America was formed, a conspiracy of slavery has always been forced upon men by other men thinking that they can live and tell other people how to live, when they cannot even live their lives in freedom. For with the subjection of others to slavery, the slave master becomes the slave to the very people they enslave. The object is power through money, an illusion. If everyone works and pays another, who does not work, part of what they earn through taxation, the slave master becomes very rich in power and money, an illusion. All people come into this world with nothing and they leave with nothing. Man was made to be free, subject only to his Creator and the rights of all men on this earth. To restrict the rights of another restricts the rights you have. Give total freedom to others in your actions toward them and you in turn enjoy freedom as it was given to each of us. When we are critical of others in the way they are living, we are in bondage to that person. Any act done to another person or their property restricts your rights by restricting your peace and joy on this earth. Our story begins in the 13 colonies with the forming of the United States. The mechanism was already in place to bring forward the deceit of ties that have plagued man since the beginning. The illumined ones chose May 1, 1776 as their day of birth in the United States of America. This statement was made in 1782, this nation that is now being formed, 200 years from now will bring in the one world government and the seat will be England. The very men who are given credit for the founding documents, in a large part, not all, sent here by King George through loans from him, or simply with the intent to once again let men think they were free, when in reality the country was already being prepared for subjection by the state. All but 6 of the signers of the Declaration of Independence were dragged from their homes in the middle of the night and brutally murdered. Such is the price of freedom. What we know as the Constitution was written and presented to the colonies as a declaration. A declaration cannot be amended. The British accredited Regency, the bar, located in New York, changed it into a constitution, much like the books of the Bible were changed into chapters and verses. It makes it easy to argue and change or amend. The people were taught to change it from the Constitution back into the declaration and vice versa. There were 18 copies of the original, but as each were located in the archives of libraries, the libraries were bummed to the ground. The practice of converting and reconverting continued through the Civil War and then stopped. In 1871, the D.C. Corporation was formed outside the Constitution and put into operation. Then through the money manipulation in the early 1900s and especially 1913, with the passage of the Federal Reserve Bank Act, a private banking system, which created a century bank for the nation, these men worked their behind-the-scenes trickery, the Wizard of Oz, the 1929 crash of the stock market by draining the money out of the system, and the subsequent Great Depression. With the election of Franklin Delano Roosevelt, March 9, 1933, the Trading with the Enemies Act, part of this deceit of EIs came into being. When the government took all of the gold from the people and made it a crime to own, or hoard, gold, the people of the United States of America lost their money, their ability to pay a debt, and they lost their EO, for it is with the ability of people to pay their debts with money that their power to establish laws comes from. He who owns the GOE DRUEs and establishes the EAW. At the same time, the government declared all property in the United States as belonging to the government and was to be used for the good of the government. Page 2 to 9. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _ Contributions, Manuals, Additional _ Collections. Language English. Item size 138.1 M. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Added date July 13, 2020, 23:01 and 35 seconds. Coverleaf 0. Identifier: The Redemption Manual. Identifier ARC/13960/T0KT5N815. OCR ABBY Fine Reader 11.0, Extended OCR. PPI 300. Scanner Internet Archive HTML5 Uploader 1.6.4. Comment. Reviews. There are no reviews yet. Be the first one to write a review. The Redemption Manual. Book Reader Item Preview. They were speaking in a federal sense. The people thought they were talking to the 48 states. Only the federal government went bankrupt, not the 48 states. The federal corporation was now brought from under the covers, and everyone was convinced that the answer was here. The deceit presented to the American people was now in full force. The governors of the 48 states of the United States all gathered at a meeting with the birth certificates of all the citizens of their states in hand and pledged the energy behind the stocks, bonds, and notes created by the federal government, who then sold them to the Federal Reserve Bank and at the same time placed like dollars of Federal Reserve notes to ensure the payment of the stocks, bonds, and notes. The problem was, the people could not pay a debt with a debt, Federal Reserve notes, without the permission or consent by assent of the people. The deceit was, how do you get people to consent to put a debt instrument against their property or assets? By creating a democracy form of government. In simple terms, is nothing more than a commercial, corporate, contract form of government, which cannot do anything but create debt. They then could not take the Republican form of government away. They had to have a way to pay their debts. House Joint Resolution 192 passed June 5, 1933 took care of the matter. The people were to be ruled by public policy, which is common law or anything that is established that the people will accept. HJR 192 June 5, 1933 established the public policy for the money that the people now did not have. 1. The government would pay the debts of the people dollar for dollar. This would be done with credit, and the only people who could issue credit was the Federal Reserve banking system. 2. The people were to be given preferred stock in this federal corporation. 3. The people were to be given a prepaid account in this federal corporation. 4. The people were the holders in due course of this federal corporation. 5. The people were to be exempt from levy. The people were then created into corporations or fictions through the birth certificates, social security numbers, and voting registration. Through these fictions, the stocks, notes, bonds were created. The credit to pay the debts would be established by the signature of the people. Money created out of thin air. The bank never loans money, only credit. Since Federal Reserve notes are debt notes, they are a liability to the Federal Reserve banks. The deceit of the Federal Reserve Bank and their agents, all corporations, only a corporation creates debt. It is a fiction, an illusion, is to get the people to allow them to place Federal Reserve notes against their assets without directly saying so, for it is a felony for anyone to request or accept Federal Reserve notes in payment of a debt. You cannot pay a debt with a debt. With the passage of the Social Security Act, the real deceit began. The federal government would now take care of you from the cradle to the grave. The Social Security Administration was created as a trust. The people apply for a Social Security card number and the Social Security Administration then as grantor establishes each person as a trust or fiction or corporation. The name is capitalized such as Jack R. Patriot is placed into the trust with the natural person. Jack Rabbit, Patriot as the trustee. All trusts or corporations report to the Internal Revenue Service through a Form 1041. We as trustees are told to file a Form 1040 as a federal employee and are charged income tax. We should be filling out the Form 1041 and no tax is paid or owed. Remember, we are tax exempt. All of the people were now held by power of attorney in the bar. Page 2 to 10. In or about 1938, a ruling on Erie Railroad versus Tompkins changed forever the American justice system. Simply stated, without a contract there is no case. Contracts became the sole basis in the federal corporation system and the court system. As the federal government is commercial, they deal in contracts. All cases in the courts are viewed as contracts. In or about 1939, the Bar Act was established in all the states and all attorneys, esquires, lawyers, counselors had to join the bar, get a number in order to practice before the courts. They do not have a license for to do so would subject them to the state giving the license. The state government is the only one who can license, not the bar or the Supreme Court of the various states. An attorney lies when he/she tells you that they have a license to practice law, for the document hanging on their wall says certificate. In 1946 another monumental change came about with the entire American system of government, when a fourth branch of government was established with the passage of the Federal Administrative Procedures Act, and every corporation, which now includes all cities, towns, school districts, etc., now set its own rules, regulations, codes, statutes, and procedures. As rules, regulations, codes, statutes, procedures are not law, they can change at the whim of the administrator of the agency so long as they do not violate the Constitution of the United States. These are simply bar rules, regulations, codes, statutes, procedures. Since the President of the Bar of New York has signed off on all of these rules, regulations, codes, statutes, procedures since 1926. In and around 1970-71-72-73, everything changed in the court system. The charge and intent came together and a person could no longer plead innocent, because he had to prove that he did not intend to do something which is impossible. You now could only plead guilty, not guilty, or no contest. At the same time all the courts were brought into one court and they became administrative/admiralty and civil, meaning commercial/contracts. We are brought into the courts and when we plead we have admitted that we understand the charge against us and the system comes down upon us. The people can never have a charge brought against them, only a claim, but the instant you say guilty, not guilty, or no contest you accept the charge. Our courts are common law and our law is established in the county you live in, for the county is your seat of government. You establish your case through affidavits and enter them into the county record, which becomes public policy concerning your case. You wait 30 days and if the affidavit is not rebutted you enter a default into the county records, make out an order for the county judge and have him/her to enforce your judgment. The government officials are called constitutors, which means anyone who swears an oath to pay the debt of another. The government has been putting their obligation to pay our debts back on us, thereby, the acceptance for valve. Read this again and again. File your power of attorney, in fact, to gain your standing in the law. File your trademark/copyright to make attorneys pay who would violate your statement. File your UCCI claim on the strawman's assets and study the redemption process, and you will not only gain your freedom, you will know you are free. Government, to forever remain inviolate. To guard against transgressions of the high powers herein delegated, we declare that everything in this Bill of Rights is accepted out of the general powers of government, and shall forever remain inviolate, and all laws contrary thereto, or to the following provisions, shall be void. Texas Constitution 1836. The Bill of Rights of the Texas Constitution has never changed. They cannot. The land will forever remain with the people. How long is forever? The last line on all the patents on the land of Texas states. The state of Texas relinquishes all hold on this land forever, and was signed by the then governor. How long is forever? Page 2 to 11. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _ Contributions, Manuals, Additional _ Collections. Language English. Item size 138.1 M. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Added date July 13, 2020, 23:01 and 35 seconds. Cover leaf 0. Identifier: The Redemption Manual. Identifier ARC/13960/T0KT5N815. OCR Abbey Fine Reader 11.0, Extended OCR. PPI 300. Scanner Internet Archive HTML5 Uploader 1.6.4. Comment. Reviews. There are no reviews yet. Be the first one to write a review. The Redemption Manual. Book Reader Item Preview. Emergency Rule Summary. Current law permanently codified at USC 95A and 95B. October 6, 1917, Woodrow Wilson submits to Congress and passes the Trading with the Enemy Act. An act to define, regulate, and punish trading with the enemy, and for other purposes. Congress, with this act, defined who was to be considered the enemy, and this act gave the government total authority over these individuals to do with as it saw fit. This Act Section 2, Subdivision C, in the middle and again at the bottom of the page, other than citizens of the United States, Section 5, B, other than credits to be executed wholly within the United States. Note, FDR served on Wilson's staff. March 3, 1933, President Hoover receives proposed executive order from the Federal Reserve Board, whereas, the nation's banking institutions are being subjected to heavy withdrawals of currency for hoarding, and whereas, these conditions have created a national emergency. Whereas, it is provided in Section 5, B, of the Act of October 6, 1917, as amended, that the President may investigate, regulate, or prohibit under such rules and regulations as he may prescribe, by means of licenses or otherwise any transactions in foreign exchange and the export, hoarding, melting, or earmarking of gold and silver coin or bullion or currency, and March 4, 1933, Franklin Delano Roosevelt's inaugural address asks for war powers. I am prepared under my constitutional duty to recommend the measures that a stricken nation in the midst of a stricken world may require. I shall ask the Congress for the one remaining instrument to meet the crises, broad executive power to wage a war against the emergency, as great as the power that would be given to me if we were in fact invaded by a foreign foe. March 6, 1933, FDR issues Proclamation 2039. Whereas is provided in Section 5, B, of the Act of October 6, 1917, as amended, that the President may investigate, regulate, or prohibit under such rules and regulations, as he may prescribe, by means of licenses or otherwise any transactions in foreign exchange and the licenses or otherwise any transactions in foreign exchange and the export, hoarding, melting, or earmarking of gold or silver coin or bullion or currency, and now therefore, I, Franklin D. Roosevelt, do hereby proclaim, order, direct and declare that from Monday, the 6th day of March, to Thursday, the 9th day of March, 1930, 3 NK holiday, and that during said period all banking transactions will be suspended. See Banking Holiday Black's EO Dictionary 4th edition. March 9, 1933, the President receives pre-approved war powers and ownership of gold is made illegal. 73rd Congress Session 1 Ch1 The actions, regulations, rules, licenses, orders and proclamations herefore or hereafter taken, promulgated, made, or issued by the President of the United States or Secretary of the Treasury since March 4, 1933, pursuant to the authority conferred by subdivision B of Sections 5 of the Act of October 6, 1917, as amended, are hereby approved and confirmed. 48 Stat 1. Sector 3. Section 11 of the Federal Reserve Act is amended by adding at the end thereof the following subsection, n. Whenever in the judgment of the Secretary of the Treasury such action is necessary to protect the currency system of the United States, the Secretary of the Treasury, in his discretion, may require any or all individuals, partnerships, associations, and corporations to pay and deliver to the Treasurer of the United States any or all gold coin, gold bullion, and gold certificates owned by such individuals, partnerships, associations, and corporations. Page 2 to 12. March 9, 1933, Senate Document Number 43, 73rd Congress, First Session states, the ownership of all property is in the state, individual so-called ownership is only by virtue of government, i.e., law amounting to mere user, and use must be in accordance with law and subordinate to the necessities of the state. 1935-36 Supreme Court rules following cases as unconstitutional, May 6, 35 Railroad Retirement Board v. Alton Railroad Co., 295 U.S. 330. May 21, 35 ALA Schechters Poultry Corp. v. United States, 295 U.S. 495. January 6, 35 United States v. Butler, 296 U.S. 1. May 18, 36 Carter v. Carter Coal Co., 298 U.S. 238. Moorhead vs. New York X. Red. Tipaldo, 298 U.S. 587. 1937 to 1938, after cries that FDR was trying to stack the court, resignation and death allowed Roosevelt to appoint enough justices of his political belief to reverse their previous decisions, and peacetime constitutional barriers to the socialist wartime agenda were removed. The original understanding doctrine was replaced with the doctrine that the Constitution was an evolutionary document. July 24, 1973, a special committee on the termination of the national emergency, Senate Report 93-849. Since March 9, 1933, the United States has been in a state of declared national emergency. These proclamations give force to 470 provisions of federal law. These hundreds of statutes delegate to the President extraordinary powers, ordinarily exercised by Congress, which affect the lives of American citizens in a host of all-encompassing manners. This vast range of powers taken together, confer enough authority to rule this country without reference to normal constitutional process. September 14, 1976, Public Law 94-412 of the 94th Congress to terminate certain authorities with respect to national emergencies still in effect, and to provide for orderly implementation and termination of future national emergencies. The provisions of this Act shall not apply to the following provisions of law: the powers and authorities conferred thereto and actions taken thereunder. 1. Section 5, b, of the Act of October 6, 1917, as amended, 12 U.S.C. 95a, 50 U.S.C. App 5, b. Conclusion: Americans are governed by the statutes codified at Title 12 U.S.C. 95a and 95b, which originated from the Act of March 9, 1933 and the Act of October 6, 1917 as amended, giving the Executive Board war powers over the people. Page 2-13. The Redemption Manual. By Robert D. Sparkman. Publication date 2002. Usage public domain Mark 1.0. Topics: The Redemption Manual, UCC, Secured Party, Creditor, Debtor, Strawman, Corporate Title, Conspiracy Theories, Natural Person, Artificial Person. Collection Manuals _contributions, Manuals, Additional _collections. Language English. Item size 138.1 M. The truth will set you free. Learn how governments and corporations claim all live births through a deceptive system of contracts and the perversion of language. See how the government is using everybody's identity for their own profits. Added date July 13, 2020, 23:01 and 35 seconds. Cover leaf 0. Identifier the Redemption Manual. Identifier ARC/13960/T0KT5N815. OCR Abbey Fine Reader 11.0, Extended OCR. PPI 3. The Redemption Manual. Book Reader Item Preview. Instruments System for Accommodation UCC 3 to 419. A. If an instrument is issued for value given for the benefit of a party to the instrument, accommodated party, and another party to the instrument, accommodation party, signs the instrument for the purpose of incurring liability on the instrument without being a direct beneficiary of the value given for the instrument is signed by the accommodation party for accommodation. B. An accommodation party may sign the instrument as maker, drawer, acceptor, or endorser and, subject to subsection D, is obliged to pay the instrument in the capacity in which the accommodation party signs. The obligation of an accommodation party may be enforced notwithstanding any statute of frauds and whether or not the accommodation party receives consideration for the accommodation. C. A person signing an instrument is presumed to be an accommodation party and there is notice that the instrument is signed for accommodation if the signature is an anomalous endorsement or is accompanied by words indicating that the signer is acting as surety or guarantor with respect to the obligation of another party to the instrument. Except as provided in Section 3 to 605. The obligation of an accommodation party to pay the instrument is not affected by the fact that the person enforcing the obligation had notice when the instrument was taken by that person that the accommodation party signed the instrument for accommodation. D. If the signature of a party to an instrument is accompanied by words indicating unambiguously that the party is guaranteeing collection rather than payment of the obligation of another party to the instrument, the signer is obliged to pay the amount due on the instrument to a person entitled to enforce the instrument only if, I. Execution of judgment against the other party has been returned unsatisfied, 2. The other party is insolvent or in an insolvency proceeding, 3. The other party cannot be served with process, or, 4. It is otherwise apparent that payment cannot be obtained from the other party. E. An accommodation party who pays the instrument is entitled to reimbursement from the accommodated party and is entitled to enforce the instrument against the accommodated party. An accommodated party who pays the instrument has no right of recourse against, and is not entitled to contribution from an accommodation party. Page 2 to 14. Private v. Public. There are only two types of jurisdictions in this entire universe, that which is private jurisdiction and that which is public jurisdiction. Everything inside your body is private because only you exist there and it is a very sanitary environment. Everything outside of you is the public jurisdiction and is full of filth. It is like when the scriptures say sweat and blood, well, that is both jurisdictions. Sweat is public because it shows how much work has been executed to your cells, and blood is internal and is a fluid operation that gives life. All rights come from the right to privacy. In the public, as for most people involved in the good fight of faith have come to a great understanding of public court, don't ask the devil to cast out the demons. For those of you that haven't realized that court is a waste of your time, keep going, and I pray that you will realize the futile effort of raising your constitutional rights and lefts. The public has no final remedy because you are relying on other people to fix your problems under execution of law, and to provide the remedy, something must die. You are the biggest problem to yourself. You have to get your thinking straight in your head before you will ever find a remedy that will last. Only you can provide your remedy, don't ask the public to save you from themselves. Remedy can only be found in a private jurisdiction, and that means in a sanitary environment, being your skull. The public jurisdiction is full of instant gratification and lascivious filth. It is the saying, you can't fix others until you fix yourself. Well, you are the solution to all of your problems. Your private existence is where you internally get to make a judgment call. It is by your internal operation that makes it private, not by the virtue of the paper. There is no dividing line between public and private, it is all on how you mentally perceive things and by their operation as to what side they fall on. Just because you say it is private, doesn't make it that way. It is how you do it or operate it that makes it that way, and vice versa. When things enter the public, they seem to get spun way out of control, prohally with the downward spiral of the public debt. To say it is private doesn't necessarily mean the information is restricted for negative purposes, probably only that to release the information into the public would corrupt it because the people can't responsibly cope with the newness of liberties that comes with private understanding. There is a veil over their hearts. That is why the Lord spoke in parables. It is because only those that are supposed to understand at that time will. Moses from Mt. Sinai first brought down the higher law/private side, and when he saw the people living such terrible lives, worshipping the golden calf, he knew it would have been a liability on his head if he were to disseminate the higher law to the public masses, so he went back up the mount, and returned with the Mosaic law/public side because that was all the people could handle. Too much unself-constrained liberties can wreak havoc on a people. The private side in its concept is that with the newness of information, which increases liberties, that wise decision-making is done as to not take
Hello?
away the liberties of others. The golden rule is, do unto
Not
others as you would have
not
them do
bad.
unto you,
How
is
are
really
you?
what sums up the private thought. The private side requires by its operation the discernment of consciences.
And Port
Page
Coquitlam.
2 to 15.
How much can I get? I would put it no lower than, say, 480.